Good morning, good evening, and welcome to the panel on competitive neutrality and the role of the state in the market. I am Federica Majorano from the OECD Economic Division, and I have the pleasure of moderating the discussion today. Let me start by setting the scene. The Secretary General, our Director, they've already talked about the importance of a level playing field. So what do we mean by competitive neutrality? We could say that competitive neutrality is a situation where no enterprise operating in a market benefits from undue advantages or is subject to undue disadvantages brought about by the state. For instance, by the state as the regulator of markets. So in this case, all enterprises, whether they are state-owned, whether they are privately owned, domestic or foreign, they should face similar rules. In this panel today, we will discuss why competitive neutrality is important in the current context, and what competition authorities have been doing in this area, what tools they have, what powers they have. We will also address a key question, which is how to balance public policy objectives on the one hand with potential distortions created by regulation or state support measures that are trying to pursue those public policy objectives. And we will conclude with some reflections on prospects and challenges for implementing competitive neutrality principles. But before introducing our distinguished speakers, I would like to tell you what we're doing here at the OECD. You've heard it already from the Secretary General and the Director. We have a new recommendation on competitive neutrality, which was approved in 2021 by the ministers of the OECD countries. This recommendation is important because it sends a signal that government intervention in the market, while extremely important and needed, especially at difficult times, as we've seen, should not distort competition and grant advantages to specific enterprises. I would just like to mention briefly the key areas covered by the recommendation. It's a very broad recommendation. So it starts with a call for adherence to adopt, maintain, and enforce a neutral competition law. But more generally, the recommendation invites countries to subject competitors to a neutral regulatory framework. For instance, new entrants should not be subject to tougher rules than incumbents. And the recommendation, importantly, invites governments to conduct reviews of legislation to identify distortive regulations. There's always a large body of new legislation introduced by policymakers for very legitimate policy objective, but we must be vigilant that this does not introduce competitive distortions. Another area covered by the recommendation is public procurement, and the recommendation calls for countries to establish procurement processes that ensure open, transparent, and non-discriminatory conditions of competition. As for state support measures, which we'll talk about today, the recommendation invites countries not to grant undue advantages that would selectively benefit some competitors over others. So, as has been mentioned in the opening remarks and even in the previous panel on sustainability, it makes sense to support specific sectors, but competitive neutrality should advise us against supporting only specific firms. Also, when exceptions to competitive neutrality are necessary because there's an overriding public policy objective, these exceptions should be transparent, proportionate, and regularly reviewed. And finally, when an enterprise performs public service obligations, the authorities should make sure that compensation for that obligation is proportionate and that the compensation is not used to cross-subsidize goods or services in other markets. At the OECD, we consider competitive neutrality a really important policy issue, and I'll just provide two examples on recent work on competition, but I'd also like to add that OECD colleagues working on trade and on corporate governance are contributing to the debate in their policy communities. For instance, doing work on subsidies in a variety of sectors. Now, back to competition. In December 2021, the OECD Global Forum on Competition discussed the promotion of competitive neutrality by competition authorities. And we have a very nice and comprehensive paper written by two colleagues that details a lot of the distortions of competitive neutrality and the tools that the various authorities have to fight those distortions. Other recent work on competitive neutrality is the ASEAN Competitive Neutrality Review in the small parcel delivery sector. And this includes lots of practical recommendations on how to achieve competitive neutrality in practice. At the moment, we're doing some work to identify guidelines to support the implementation of the recommendation in practice. So stay tuned and please follow our work on this. I'm sure that today's panel will be a great opportunity to drill down on some of the most pressing policy issues. Now let me welcome and introduce our speakers, whom I thank very, very much for accepting our invitation. Starting with Damien Neven, is a professor of economics at the Graduate Institute in Geneva. He's also a senior academic consultant in Corpus Lexicon and has acted as chief competition economist at the European Commission from 2006 to 2011. His current research interests focus on enforcement standards, subsidies, and standard essential patents. Julian Peña is the partner in charge of competition law at Allende Embrea in Argentina and is also professor at Universidad Torquato Di Tella's Masters of Law and Economics. He is the founder and moderator of Foro Competencia, a vice chair of the Antitrust Committee of the International Bar Association, and a member of the advisory board of the Fordham Competition Law Institute and the American Antitrust Institute. Nicole Robbins is a partner at Oxira Consulting. She is the head of the Brussels office and leads Oxira's stated practice. In particular, Nicole advises clients on economic and financial issues associated with a diverse range of state matters in many, many sectors. And finally, Rhonda Smith is a senior lecturer in the economics department and a senior fellow in the law school of the University of Melbourne. She's also a former commissioner with the Australian Competition and Consumer Commission and was a lay member of the High Court of New Zealand for some years. At the moment, she's a member of the Copyright Tribunal. I would like to welcome you all. Before starting with the first question, just to note for our audience, please send your questions through the conference platform. At the end of our panel, we'll set aside 15 minutes, and so our panelists can answer live. And now I'd like to turn to Rhonda for the first question. So as I said, we'll start by setting the context for this discussion and to say why competitive neutrality indeed matters. So the recommendation on competitive neutrality approved in 2021 was really developed and approved against the backdrop of the pandemic and widespread government intervention. Together with the associated questions on whether all the state support may distort competition. And at the same time, there's also an ongoing debate on how subsidies can distort international competition. So this very difficult context brings us to the question of why we need competitive neutrality. Starting with Rhonda, please.
Probably a good place to start in answering that question is to think about what it is that competitive markets actually provide us with. And in a competitive market, what we find is that firms are striving to win sales from their rivals and to avoid sales being lost to their rivals. And absent market failure, what that does is it ensures that we have efficiently operating markets. The costs will be kept down, that businesses that are not efficient will exit the market and the resources will be released to others, and that businesses will be dynamic, that they will be innovative, that they will respond to change. And I think we can then ask the question, well, what happens if we don't have competitive neutrality? What's the consequence of that? Well, the first thing that we can say is that government businesses, government-owned businesses, and you only need a small amount of ownership, so it doesn't need to be a firm that's totally owned by government. First of all, they may not be subject to taxes and charges, where their private sector rivals actually are subject to that. Likewise, regulation. They may not be subject to regulation. Private sector rivals are subject to regulation and incur costs as a consequence of that. It may be that government-owned businesses get an advantage in terms of access to finance. Easier to get finance, cheaper to get finance, because there's an implicit government guarantee to that finance. And it may even be that government directs government departments and other government businesses to source from government-owned businesses. So there's a captive customer group. So what we've got here is an advantage, a cost advantage that goes to these government-owned businesses that has nothing to do with their efficiency, has simply to do with their ownership. But of course, we also need to recognise that some of these businesses incur additional costs simply because they're government-owned. So it may be that they're required to have much more detailed reporting. It may be that they have higher standards in terms perhaps of safety. It may be that they have uncompensated community service obligations. And there may be other things as well. So what we're interested in is situations where there is a net cost advantage that's conferred as a result of government ownership. And what does that do? Well, essentially what it means is that the government businesses are not competing on their merits. They're not competing because they're doing things better. They're able to win customers simply because of the benefit that they get from government ownership in the form of lower costs overall. What does that mean? Well, it means that they're going to reduce the competitive constraint that's imposed by private sector businesses. And in fact, it may even be that they foreclose, that they actually drive the private sector businesses out of business. Also, it's likely that they will raise barriers to entry. So if you've got a new entrant looking at coming into a market, they look at the role of government and they realise that despite the fact that they would be efficient once they entered, they're not going to be able to compete because of the advantage that the government-owned business actually has. So what we've got is a misallocation of resources that results from the lack of competitive neutrality. But it gets worse. If we have government businesses exporting, then of course what they're going to do is have the same effect in export markets as they've had in the domestic market. You might say, well, probably these are not the businesses that are going to be exporting. Well, that may be true, but the likelihood is that those government businesses are supplying into domestic businesses that are exporting. And so it will be those businesses that will have the effect of distorting the resource allocation in those export markets. So what does competitive neutrality do in terms of benefit? It actually means that we get rid of those distortions, that we have firms that compete not on the basis of their ownership, but on the basis of efficiency. Thanks, Frederica.
Thank you very much. And thank you also for flagging the role of state-owned enterprises, which many times have got the objective of pursuing specific public policy objective, but at the same time, these are accompanied by certain advantages. And indeed, it's a really important consideration, considering that SOEs tend to be very large firms nowadays. I'd like to quote an IMF report from 2020, estimating that among the 2,000 largest firms globally, 20% are SOEs, and this was double the percentage 1 decade earlier. And we've observed SOEs going out in international markets, and so there's a trade and investment element that perhaps we can comment on later, as we'll also like to comment later more extensively on the Australian experience on competitive neutrality and the really important contribution there. Thank you. So if we stay on the same topic of the context, I would like now to ask Nicole another question. So if I may add to the context, again, in which we're having this discussion, there has been an increase in government intervention, not just because of the need for emergency measures for the pandemic, but also in response to the many challenges today, such as supply chain disruptions, relocation of businesses. So my question to Nicole is, can we still talk about competitive neutrality given the context, or is it something that should be kept for the good times only? Nicole, over to you. Thank you.
So it's an interesting question that you raise. I think, in my opinion, in times of crisis, there may well need to be a greater role for the state. However, this does not necessarily mean that we should lose focus on competitive neutrality. So, as you've mentioned, following the onset of the pandemic, alongside the significant amounts of aid that's been provided, competition authorities have shown an increased willingness to allow companies to collaborate in order to overcome possible supply chain disruptions, providing this is done on a temporary basis and Now, more recently within the EU, we've seen a focus placed on ensuring that there's sufficient production within the EU of certain strategically important products. So in particular, I'm referring here to the recent discussions about how to overcome supply chain shortages of semiconductor chips, which are key building blocks of certain goods such as smartphones, as well as cars, and a whole range of products. Now, recently the Commission has announced that state aid rules should be more flexible if the facilities to produce these chips would be first of a kind in the EU and would not otherwise be developed in the EU in order to ensure their security of supply of these component parts within the EU itself. Now, it's important though at the same time to make sure that any distortions to competition are minimised as much as possible. So while indeed there may need to be a greater role for the state during times of crisis, I think efforts should still be made to ensure competitive neutrality in such times, and in particular in making sure that any interim measures are time limited and focus on the key issues, which, as you refer to in the context of the pandemic, some of the key issues have been around the supply chain and possible disruptions.
Thank you, Nicole. And I would like to stress what you said about limited duration and very targeted. Perhaps it's something that we can elaborate on later on as we talk about state aid more extensively. So after this introduction on the overall context, I would like to ask a question to Damian. Now we're moving into the discussion on competition policy and on the role of the authorities. So I think given what we've said so far, we could argue that competitive neutrality actually requires a whole of government approach. So it's not only a technical type of intervention by competition authorities. Still, competition authorities are the driving force of this concerted effort. So now we would like to discuss what tools authorities have to promote competitive neutrality, whether specific legislation to deal with competitive neutrality, which some jurisdictions have, is helpful. So, Damien, over to you, please.
Yes, thank you very much, Federica, and thank you very much for inviting me to take part in this panel. This is a pleasure. In answer to your question, I think I'd like to say something about the role that competition authorities have to play towards the rest of government, so to speak, and so in a second step, also discuss the role that competitive neutrality has to play or not in the enforcement of the statutes of the competition authority. So in the first part, I really would like to discuss the contribution towards the competitive neutrality as a whole, as a system of government, and then focus on enforcement. Now, as you mentioned in your introductory remarks, I mean, the OECD has done a lot of work regarding the role that competition authorities can play and regarding the instruments that the competition authorities have. And this evidence really highlights the fact that competition authorities have a role to play in terms of the oversight. That is to say, they can essentially advise the government on the design of the policies that they are putting forward, the regulation, the support scheme, to ensure that these instruments minimize distortion. So it's really a role of advice in terms of the design. It's also a role in terms of the oversight, that is to say, of finding out whether these, or assessing whether these instruments are applied, are implemented in such a way as to minimize distortions. Now, and as the evidence put together by the OECD shows, there are a number of instruments that can be used. I mean, that ranges from simple advocacy to the use of market investigations. And as you mentioned, I mean, in some jurisdictions, there are some specific provisions and some specific competencies for the oversight of government policies from the perspective of competitive neutrality. Now, there's just one aspect that I'd like to highlight with respect to the choice of these alternative instruments, and this is the concern about potential negative externalities across the different functions that the competition agencies perform in between the different roles that they play, and in particular between enforcement and advocacy. And I think it's useful to try to trace out what could be potential negative consequences of advocacy activities towards what is the main function of competition agency, which is enforcement of the competition statutes. And that's particularly the case for those competition agencies that operate in an environment in which there is essentially inquisitor, I mean, in which they operate in the context of inquisitorial procedure. And an inquisitorial procedure actually requires, I mean, to act as a balanced inquisitor. I mean, to essentially, it requires balance in the arguments. It requires respect for the rights of the parties involved. It sort of requires consideration of all the arguments, and overall, a lot of intellectual discipline, both in terms of the law and in terms of the economics. And of course, decisions by competition agencies in their enforcement function are subject to review in the courts, and this by itself provides the incentive to respect the standards in terms of intellectual discipline and in terms of the balanced evaluation of the evidence. Now, the issue is that the discourse when it comes to advocacy is very different. I mean, when it comes to advocacy, as the name suggests, I mean, the argument is to advocate, or the perspective is to advocate, and the arguments are not the same. The arguments are not supposed to be as balanced, and the arguments also tend to be looser. They tend to be less technical. And I think that one can see actually the potential difficulties that this leads to, this sort of two different types of discourse very well. It's very well illustrated by the European Commission. It's very well illustrated by the fact that the competitioner, sometimes the competition commissioner has to comment on enforcement cases, and so has to represent the agency as, has having undertaken a diligent, balanced assessment of a case. And on the other hand, she also has to, or he or she also has to advocate for competition, and she has to advocate for competition, including competitive neutrality, in very different fora. I mean, for instance, she has to do it in Parliament. And it seems to me that there is a risk in having an external effect from advocacy, in which the discourse is quite different, into the main enforcement function, which requires a different type of approach and a different type of discipline. So that from that perspective, I would think that it is probably better when competition agencies do get involved in this oversight function or accountability function. It's probably better to do it in the context of a very well-defined framework. That is to say, in the context of a specific law, or in the context of a specific set of tasks or a specific regulation, and possibly better to do it with a different organization, rather than have this function being part of the competition agencies, possibly to entrust it to a sister organization. Let me now turn to the extent to which competitive neutrality has an effect on enforcement. And here, I want to make 2 points, really. I want to make a point with respect to, again, the extent to which competition agencies are involved in applying principles of competitive neutrality with respect to their oversight on the actions of government, and second, the extent to which competition agencies are led to consider principle of competitive neutrality in the enforcement of the traditional tools, that is to say, in the context of the EU, Article 101 and Article 102, towards the conduct of particular enterprises. Now, first, with respect to the oversight or the role that agencies play in assessing the government actions. Now, in the context of the EU, and here my remark is fairly EU specific, this is organized through the interface between Article 106 and Article 102 of the treaty. I mean, Article 106 is really about the enterprises that are granted special and exclusive rights. And I mean, there is the Commission is supposed to implement Article 106 together with Article 102, which essentially is trying to ensure that whenever government grants special rights to particular enterprises, they do so in such a way as not to impair competition. Now, the experience with respect to the enforcement of these provisions raises a number of issues. I think that the first issue which arises is an issue of consistency across instruments. I mean, let me take an example here. The consistency that I have in mind is consistency between regulation on the one hand and state aid enforcement on the other. And again, to be concrete, consider a very specific case of subsidies on the one hand that could be granted in the state aid framework as a compensation for service of general economic interest. I mean, there is the whole sort of approach in the state aid rules in order to make sure that what is granted to companies that provide services of general economic interest is not excessive. Okay, and so there is an assessment there of the amount that is granted. Now look at exactly the same issue from the perspective of regulation, because I mean, you could have regulation that grants special rights and special responsibilities to enterprises, for instance, in the provision of services of general economic interest. And then the perspective that is taken under 106, 102 is actually the question of whether a restriction of entry is actually acceptable, whether a restriction of entry is actually accessible from the perspective of not putting into danger the provision of the special service, the provision of the services that the entity has been entrusted with. So we see that on the one hand, there is a state aid approach that looks at the adequate compensation. On the other hand, there is an approach under Article 106, 102, which rather than looking at the compensation is looking at whether restrictions with respect to entry might actually be justifiable when the objective is to make sure that indeed the enterprise that has special rights and obligation is in a position to complete its mission. So essentially, we have two provisions that apply different logic, and it's clear that these provisions also have different objectives, and that raises potentially an issue because state aid provisions are not about consumers, they are not about customers, but they are essentially about competitors. And the implementation of Article 106, 102 is supposed to be about restrictions of competition under 102, and the assessment there, the objective is actually to protect consumers or customers. So that we can see that we have here two different instruments that potentially achieve the same thing, but are being assessed from the perspective of competitive neutrality according to different criteria. And so there is an issue of consistency there. Having said this, I mean, one should not exaggerate the significance of the difference in practice, which by itself may not be a reason not to be concerned. And my observation here is that Article 106, 102 has been to some extent enforced a little bit like a state aid provisions. I mean, if you look at the case law under 106, I mean, I'm thinking in particular of cases like Dimosia in Greece. This is a case in which arguably, there was no concern in terms of competitive distortions that might hurt, at the end of the day, consumers or customers, but there was really an issue in terms of allocation of rents among different parties. So that arguably, even in that case that was run under 106, 102, the concern was not so much about final consumers or customers, but the concern was again more in terms of the balance between different agents that might perform the function. In this particular case, it was the provision of electricity from lignites. So my main point here is that when it comes to the actual enforcement tasks of competition agencies towards government interventions, there is an issue of consistency. The second point I wanted to make relates more to the extent to which competitive neutrality has a role to play in the enforcement of the traditional instruments, that is to say, instruments towards agreements and instruments towards abuse of dominance. And in particular, to see whether competition agencies should apply competition rule differently towards firms that have special and exclusive rights, and consider the conduct of these firms differently. Let me again take a very simple example. I mean, consider a dominant firm, potentially a dominant firm, that is performing some services of general economic interest. Now, consider a claim that this firm is undertaking predation, excessively low prices, in some segments that are open to competition. Now, if in the enforcement you consider that all the common costs associated with the provision of services of general economic interest are not taken into account in order to assess the level of cost in the context of the price cost test, then the dominant firm that has a service of general economic interest mission is much less likely to be found in violation of Article 102, and so much less likely to be found in violation in terms of predation. So that, I mean, then the question arises: do you want, when you are faced with a company, a dominant firm, that has a mission in terms of the provision of services of general economic interest, do you want to adjust the test? I mean, do you want to recognize the fact that possibly competitors of that firms are actually much more vulnerable to predation in the context of what in my example, than towards firms that would not have these services of general economic interest mission. So this is just one example, but it says that in the enforcement of 101 and 102, one is confronted with situations in which companies that have special and exclusive rights, I mean, possibly should be assessed differently from those that don't. I mean, and possibly some specific tests should be developed. But this actually leads to, I think, a wider issue in enforcement, which is the question of whether, instead of focusing on competitive neutrality, one should not consider also competitive redress, because there is I guess, a slightly ambiguous perspective in the enforcement of competitive neutrality. And the ambiguity arises from the fact that, on the one hand, one recognizes the significance of public policy objectives, and one accepts that in order to fulfill these public policy objectives, some specific support on some specific regulation is appropriate. And at the same time, one is trying to minimize the distortions that are associated with the intervention. But at the end of the day, this is a trade-off, okay? You recognize a public policy intervention and you try to minimize the distortion. So one possible perspective towards this situation is to say, okay, rather than simply minimizing the competitive distortion, why not consider instruments that will lead to competitive redress? That is to say, to grant to competitors a potential set of different rules, or a potential compensating measures, such that they will again put on equal footing, such that there will be a level playing field. So I just like to shift the debate a little bit from simply competitive neutrality applied in a passive way towards a framework of competitive neutrality, which is applied in an active way by granting competitive redress. Thank you very much.
Thank you. And a lot of food for thought for the guidelines we'll be developing. I'll pick up on this last point on redress and ask a question to Nicole, in case. Like requiring airlines that were receiving state support to divest slots. So the question for you is competitive redress desirable? What is the impact that we expect?
Yes, I think for certain types of aid measures, some form of competitive redress is indeed desirable, as aid will naturally distort competition. And that's particularly the case for aid that's provided to firms in financial difficulty, who without the aid would have likely have exited the market. Now, remedies imposed in such cases to limit the distortions of competition are typically either structural remedies, such as divestments or downsizing of business activities, as well as behavioural remedies, such as the ban on acquisitions, for example. Now, such measures were introduced quite extensively during the financial crisis in 2008 as part of the package of aid that were received by certain financial institutions. But there's been quite a lot of debate ex post about whether the measures were actually sufficient. More recently, as you allude to in your question, for the most distorted forms of aid that's allowed under the framework for state aid rules to be introduced in light of the pandemic, remedies are required under certain conditions. And as you've highlighted, certain large airlines that have received aid, this has been in the form of slot divestments. Now, more generally, I think there are question marks, particularly in the aviation sector, at this particular point in time, about how to make such remedies as effective as possible. And that's, I think, far more complex in the current circumstances, particularly in aviation, where the sector is recovering from the impact of COVID and where there's quite a lot of uncertainty about how the sector will recover and the speed of the recovery as well. So while indeed there may be some challenges in making sure that the remedies are as effective as possible, I would agree that some form of competitive redress is appropriate for certain types of aid measures.
Thank you very much, Nicole. Julian, would you like to comment on this point, please?
Sure, thanks, Federica, and thanks for the invitation once again. I would like to, in Latin America, we do not have anything similar to the European Union's state aid regulation. In fact, Latin America is a very broad concept that covers a lot of countries, and we do not have a common treaty or legislation or institutions, but we do have a common background, historical and cultural, legal, economic background. So we can find, even though we have countries that have a very different reality and size, we do have certain common patterns with regard to state intervention in the markets, and we have a very long history of very strong intervention in the markets. Therefore, it is embedded in the culture of most of the countries of the region, and this makes very difficult. Although there are some countries that have instruments to promote competitive neutrality. At the same time, they face a very difficult context in order to enforce it or to convince the authorities that state intervention should be neutral. I think that asking for state intervention in the markets in Latin America can be a double-edged knife, because based on the historical experience, the intervention has not been neutral to competition, and therefore I think that initiatives like the OECD recommendations will help a lot to give incentives for the different governments to start addressing this issue, but it is not an issue that it is in the culture of most Latin American countries.
Thank you for your remarks. And still staying on the question of tools that competition authorities have, I would now like to ask Rhonda about specific provisions on competitive neutrality, like in Australia. So in some jurisdictions, these provisions are not part of the competition law. So I'd like to ask you to reflect on this and on the consequence of having separate provisions for competitive neutrality that are outside the competition law.
Thanks, Federica. The competitive neutrality provisions are not implemented through the competition law, and neither does the competition authority, the ACCC, have a role in enforcing competitive neutrality. So it's a fairly different situation. The nature of this arises out of a constitutional issue. It would have been difficult, given the constitutional powers available to the Commonwealth Government, for them to have legislated. And so the way in which competitive neutrality was introduced in Australia was through an agreement between the Commonwealth Government and the various state and territory governments. And this was known as the Competition Principles Agreement. It was a much broader agreement than simply competitive neutrality. It included a range of other things, but it certainly did include the competitive neutrality provisions. The Competition Principles Agreement set out, as the name implies, the principles for introducing competitive neutrality. but it was left up to the individual governments to actually introduce or to develop the process for the implementation of the policy. And that, of course, meant that there were not differences of principle between the different governments, but certainly differences of detail in terms of the way in which the processes worked. And this was dealt with through the publication of guidelines. But it gets us to that point where there are problems associated with the competitive neutrality policy because of, I think, in my opinion, the way in which it was introduced. And the first problem that we've got is simply a lack of knowledge and a lack of understanding of the policy itself. So business generally doesn't understand the policy well. Lawyers, in fact, don't understand the policy all that well. And they don't know where to go when there's issues associated with compliance in a lot of instances. So there's this lack of information out there that I suspect would not have been the case had the policy been introduced through the ACCC, through the Competition Authority. People generally understand that the ACCC deals with problems that are associated with competition. And this would have been seen as such a problem, and people tend to look to the ACCC to address the problem. So that's one problem. The second problem is one of enforcement. And that is that each of the governments have set up their own body for providing advice to government businesses about the way in which the policy should operate. And they've also dealt with or provided for dealing with compliance issues. Now, at least after a period of time, these bodies dealing with these problems actually became part of more general bodies that were dealing with a whole range of different issues. So they're not specialist bodies. Given the first problem, the problem of lack of understanding, there haven't been a lot of complaints. There haven't been a lot of issues raised about compliance. On the one hand, one might assume that that means that there hasn't been a problem, but I think more likely it is that people simply haven't known where to take their problems. But it does mean that these people are not developing expertise in terms of dealing with the problems, and that itself can be an issue. When they do find that there's a problem, and I should perhaps exclude the Commonwealth body from that, because the Commonwealth does have a much more specialised body, and it has dealt with a number of major issues. But having investigated a complaint, decided that there's a problem, then the inquiry body simply refers the matter back to the government business concerned. So the assumption is that they will fix the problem, but there's nothing to follow up on that. There's nothing to compel them to fix the problem, to do it within a reasonable time frame, or indeed to do it at all. So there's no penalties for compliance, which there may have been had it been introduced through the competition law. There has been an attempt in one case, having got a ruling that the conduct was not conforming to competitive neutrality. There was an attempt to run a case under Section 46, the misuse of market power provision, in the court. Very difficult to run a Section 46 case anyway, and extremely difficult to run it when the problem was really a competitive neutrality problem. The matter settled, we didn't get a ruling out of the court. We've also recently had a case run by the ACCC, which was not run as a competitive neutrality matter. It was run because there was an agreement and some terms in the agreement, which if we looked at them with a competitive neutrality lens, we would have said this is a competitive neutrality problem, but that wasn't the way it was run. So two problems: one, a lack of knowledge, lack of understanding, and the second one, a lack of means of getting a response. We have relatively recently had an inquiry into competition policy and a recommendation from that in terms of competitive neutrality that we need a greater transparency, but no recommendation in terms of enforcement. So by not putting competitive neutrality into the competition law, I think we've got a couple of problems that have followed from that.
Thank you, thank you. And indeed, there is this contrast between regimes in which competition authorities can directly enforce competitive neutrality principles, versus other regimes in which they've got to take the authorities to court, and the latter, I think, tend to be slightly less effective. I would like now to move to the question of balancing, and with a question to Nicole. As we've said already in this panel, the implementation of competitive neutrality in practice sometimes requires balancing public policy objectives with potential distortions that are created in pursuing these public policy objectives. And I would like to ask you what analytical framework we should follow in this balancing exercises, and with specific reference to support measures. And if you could please extract any lessons from the EU framework on state aid for us that we could use more generally for competitive neutrality.
Thank you, Federica. So as you highlight, perhaps one of the main tensions when implementing any sort of competitive neutrality regime is to ensure the balancing between achieving the public policy objectives against potential distortions that may be created by the regulation or by the state support measures. So, for example, it's generally accepted that state funding may distort competition by potentially crowding out private investment, affecting perhaps the location decisions of firms, or potentially creating or maintaining a firm's market power. Now, in order to ensure competitive neutrality, ideally the public policy measures would be designed in a way that is as least distorted to competition as possible. Now, under the EU state aid framework, there are a number of characteristics that can be identified to try to identify those most distortive subsidies. And those are on the basis of a variety of characteristics relating to the form of the subsidy. So, for example, whether it's provided on a rolling basis over a long period of time, as opposed to a one-off measure, as well as a variety of company and market-specific characteristics. So, for example, if the amount of the subsidy is large relative to the overall size of the market, or if the subsidy is granted to firms with market power and already firms serve the majority of the market, well, in that case, the subsidy is more likely to distort competition. So there are a number of lessons that can be drawn from the EU state aid framework, which could help shape the design of regimes to ensure competitive neutrality. And that's really in two areas. The first area is assessing whether any support provided by governments, whether that confers an undue advantage on the company or enterprise itself. And then in the second part, in terms of balancing the positive effects of the funding in order to achieve the public policy measure against the potential negative effects. So if I start with the first point, the OECD's recommendation, as we highlighted at the start, emphasises that governments should avoid offering advantages that distort competition and benefit certain enterprises over others. So as an example that's given in the recommendation is loans or loan guarantees from the state that are not in line with market conditions. Now, in order to assess whether the funding that's provided by a government is in line with market conditions, there are a number of insights that can be drawn from the EU state aid framework in terms of the economic and financial techniques that could be used. Now, in the state aid context, economic and financial techniques are often used to assess whether intervention by the government is on market terms, and that's through what we refer to as the market economy operator principle, the MEOP, which under EU state aid rules, it's an important tool to assess a wide variety of measures provided by public authorities, such as capital injections, loans, and guarantees. So to take an example, if we're assessing whether a loan provided by a government is on market terms, the test is whether the key characteristics of the loan, the interest rate, the amount of the loan, the duration of the loan, whether it would have been provided by a private investor in similar circumstances. So there's certainly a number of lessons that can be drawn in terms of techniques. Now, if on the other hand, the government support is provided not on market terms, the OECD's recommendation highlights that compensation must be transparent, proportionate, and periodically reviewed. And again, a number of lessons and insights can be drawn from the state aid framework, where if funding is deemed to constitute aid, a balancing exercise is undertaken to determine whether the positive effects of the aid outweigh its negative effects. And in particular, when assessing the impact of the aid on competition and trade, the likely impact of the aid on the recipient and on the recipient's competitors is compared against what would have been likely to occur in the counterfactual scenario without the aid. Now, in addition to highlighting that funding provided by governments must be transparent and proportionate, the recommendation on competitive neutrality also emphasises that remuneration that's provided to enterprises for undertaking public service obligations must be calculated based on clear targets and objectives. And again, this is very similar to the framework for services of general economic interest under state aid rules, where the focus is on making sure that the funding does not lead to overcompensation, amongst other criteria. So there are a number of parallels that can be drawn from the EU framework. Now, state aid rules have, however, been tested during the recent pandemic, and indeed there have been a number of concerns raised about the distortive effects of large amounts of aid provided by some member states during the crisis and the asymmetry of the response across the EU. Now, in contrast to assessments of the compatibility of aid during non-crisis times, for a number of aid measures that have been granted under the state aid rules introduced in response to the pandemic, an assessment of the impact of the aid on competition is not actually required. Now, to an extent, such concerns could be partly overcome going forward by placing greater weight on the assessment of the impact of the aid on competition and trade. And more generally, evaluations of the impact on funding from governments on competition could also help to identify lessons for the design of future funding measures and schemes in a way that mitigates their impact on competition. And the lessons from such evaluations required under the EU state aid framework for certain aid schemes could be helpful for shaping the design of any competitive neutrality regime. So just to conclude, while there are certain limits of state aid rules that have been identified in response to the recent crisis, there are a number of lessons, though, that could be drawn from the experience in the EU that could help to shape the design of a future regime for competitive neutrality. And that's particularly in relation to the assessment of whether the funding is on market terms, and they're making sure that if it's not on market terms, helping to minimise the impact of the support from the government on competition and trade.
Thank you, Nicole. I would like now to ask Rhonda for a quick answer about how the Australian framework works in terms of making neutrality adjustments whenever an enterprise enjoys a certain benefits. So it seems like it's almost automatic, but is it possible to always correct any competitive advantages, and is it such a straightforward process?
Thanks. I'm not sure that it's always possible to correct, but we certainly can have a reasonable try at it. I think we need to identify, well, certainly the Australian situation identifies, first of all, whether firms are susceptible to competitive neutrality policy, because there are exceptions. And then secondly, to look at the compliance with the program, or how to comply with the program. So in fact, competitive neutrality in Australia only applies to significant government businesses. And those government businesses are defined as having an annual turnover of $10 million or more. Now, we could talk about whether $10 million is an appropriate amount or not, but anything under that is not going to be covered by competitive neutrality. The second thing about it is that competitive neutrality only applies if it is in the public interest. And so that implies a cost-benefit analysis, except that essentially it's been decided that the costs are minimal. So the costs are essentially administrative, they're not terribly large, they're put to one side, and then the focus is on what are the benefits that come from the competitive neutrality application. And that's assessed primarily in terms of efficiency effects, but other effects might be taken into account, for example, environmental effects or public health effects, those sorts of things. So once it's decided that a business is susceptible to competitive neutrality requirements, then the question becomes, first of all, making sure that they're subject to the same costs as their private sector rivals. And that goes back to what I said in the first question that was answered, was asked rather. And that is looking at tax, looking at the regulatory environment, making sure that the costs associated are evened up and so on. The issue that Nicole mentioned, which was that of financial issues and interest rates. But then there's a second issue that needs to be looked at. If we've got government businesses that are not corporatised, such as a not-for-profit that actually has some business element within it, but it's a fairly minor part of its activities, then we need to make sure that we're going to fully allocate the common costs associated. And the process that's used for that is either some form of apportionment based on some measure. Let's say, for example, it might be based on the percentage of employees in the overall organisation, and what proportion of those are in the trading component of it. And the alternative to that, and perhaps the easier one to apply, might well be avoidable cost, which we're all familiar with from its use in competition analyses elsewhere. We've also got to offset the disadvantages, of course, that the government businesses incur as a consequence. Community service obligations need to be compensated for, and I think Damien mentioned, or maybe Nicole, that we need to make sure that those funds are not being used to cross-subsidise other sorts of things. So there's an element of that involved. Once we've got the costs, then the question becomes, is the price that's being charged sufficient to earn a commercial rate of return in the medium to long term? Of course, there's the issue of what do we mean by the medium to long term? How do we measure the commercial rate of return? Well, we can look at a comparable private sector business and look to see what returns they're earning over a period of time. We might take the bond rate and adjust it for risk, and there are some other ways in which we could do it as well. The big problem that we face there is new businesses, startup businesses, which specify initially what they expect to earn, and then a bit further down the track, you find that they haven't earned that, or they don't look as though they're going to earn that over a reasonable time frame. And then the question is, how do you deal with that? Market conditions can change, or were the figures at the beginning not realistic figures, and how do you deal with that in the context of competitive neutrality? So there's some issues in there that I think are anything but clear cut. I think dealing with competitive neutrality and getting the right answer, which was the question that was asked, is on the one hand much simpler when you're dealing with government-owned businesses. It's actually much more difficult when you're including government policy within your competitive neutrality framework.
Thank you. And indeed, we've spoken quite a lot about state support measures, but I would like now to move to the regulatory framework and ask Damien for a brief comment on this matter. So how can we adapt these principles of balancing to other areas such as competitive neutrality in the regulatory framework? How can we balance achieving public policy objectives with potential distortions of competition? And finally, does it mean that all competitors should always be subject to the same rules?
Yeah, thank you so much. And this is a very difficult question. And I cannot provide anything close to a very comprehensive or even cogent answer. Let me just highlight just a few aspects of this. I mean, in terms of, in conceptual terms, of course, I mean, assessing the public policy benefit and trading off the public policy benefit against the distortions is something that can be undertaken for state aids and can be undertaken in the same way for the consequences of a regulatory framework. I mean, focusing, of course, on those regulatory frameworks that introduce a significant asymmetry between different firms. So conceptually, I mean, the problem is not different. What I'd like to highlight, though, is that, and it's also in light of the state aid experience, is that this balancing is much easier to achieve when you have prices. That is to say that, I mean, inherently, the public policy interventions are solving some external effects, okay? I mean, and in a very broad sense. And assessing the benefit from internalizing these external effects is much easier when you have prices in order to guide the assessment. And if you don't have prices, I mean, think about a very simple example, because I mean, these issues of balancing actually arise in many different areas in competition enforcement these days. I mean, it arises in state aids, it's right with respect to competition, with respect to competitive neutrality. It also arises with respect to the debate on Article 101, paragraph 3, that is to say, of the benefit from potential agreements. And I think that the experience from these various fields is that if you have, for instance, in the case of 101, paragraph 3, a benefit in terms of environmental protection that can be measured by a price, I mean, which is the price of a CO2 emission, for instance, or the price of an NOx emission, this is much easier to undertake this balancing, okay? So I think that, you know, focusing on those areas in which you have pricing mechanisms to put a value on the benefit is much easier. And I mean, the second remark I'd like to make, which really follows on this one, is that in many circumstances, you should have limited ambitions, okay? I mean, and there is always a risk that there will be some illusion in the precision in numbers. That is to say that, you know, you will want to achieve a balancing in terms of euros, which on the one hand has a benefit in terms of the internalization of external effect, and on the other hand, as a cost in terms of competitive distortion. But, you know, one should be humble with respect to that sort of assessment. I mean, all what you can hope to do probably is to get the order of magnitude right, but you not have the ambition of trying to get this right to the level of the million euro, I would say.
Thank you. And we're approaching the end of our panel. So our concluding topic is the way forward. So prospects, challenges for a wider implementation of competitive neutrality principles. So I would like to start with Julian with a reflection on Latin America, please.
Sure. I think that it is important to put this recommendation in context of what is going on in Latin America. And I find some factors that will help the implementations and some factors that will challenge the implementation of the recommendation. On the factors that will help the implementation, one is the growing influence of the OECD in the region. We have already 4 members four Latin American members of the OECD, and last month 3 other countries were invited to join the OECD. But most importantly, the OECD has launched 20 years ago the Latin American Forum, regional forum, together with the IDB, and that has led to building a strong network with the different competition agencies around the region. In fact, that has been enhanced 3 years ago with the launch of the competition regional center together with INDECOPI in Lima. So that is an instrument that will help a lot in the implementation. The other is the fact that although, as I said before, the culture is not is of a strong state intervention in the market. In the past 30 years, there have been a lot of changes in the region and consolidation of competition law. Of course, with certain setbacks and it has not been very similar in all the regions, and it depends on with some flexibilization as well, especially lately with COVID. But the trend shows that there's an openness to receiving changes, and that is something that a reason to be optimistic. The challenges that I see basically is the changing paradigm of state intervention in the market. As I said previously, historically there has been a very strong state intervention in the market paradigm, and that has been manifested in all sorts of manners. In fact, some economists have called the period from 1930s to 1980s as the state-led industrialization process. So that has been a very extreme position that during the 90s, and thanks to the so-called Washington consensus policies, there has been a pendulum shift towards less intervention in the market, but it was not a very, it was not fully implemented. Perhaps with the crisis of 2001 in Argentina, that could be the formal end of the consensus on the Washington consensus policies in Latin America. And since then, we see in the past 20 years a very different situation in which there is not one pendulum. There are different countries have different positions around the range of the pendulum, and some countries have even moved back and forward from the pendulum in this past 20 years. So this has a direct impact on how societies and governments perceive state intervention in the markets. Nowadays, as in many places in the world, but in Latin America in particular, we see a highly divided society with regard to which way should the pendulum go. Another issue in the past 20 years is that China has become the most important trader, the most important investor, and most important lender of most Latin American countries. And as you know, China is a strong supporter of state capitalism. There are also some structural issues that that affect the implementation of these recommendations. I'll point out basically one is the endemic corruption, and that is something that recently Transparency International has reported. They have issued their annual report and have shown that most Latin American countries have a medium to high levels of corruption. And the other is some vested interests that are directly linked with the financing of the campaigns. Therefore, these are some elements that are structural in Latin America and that play a role. Finally, the COVID-19 effects have hit very hard the region, and that as a result, it has led to a request for higher state intervention in the markets. Combining all the factors, I'm optimistic that about the implementation of these recommendations, but certainly it will not be an easy task.
Thank you. And I would like to stay on this topic with a question from the audience. It's a question from Sam Baldwin. He asks, state governments have a natural incentive and tendency to depart from the principle of competitive neutrality when an opportunity arises to support national champions and regional business interests. How do you persuade governments to pursue competitive neutrality when doing so is not necessarily in its short-term interests? And I'm asking this question generally to the panel, whoever would like to pick it up.
I mean, I would say it's really, I think it's a difficult balancing that, but I would say it's really in terms of emphasising the sort of medium to long-term benefits, because perhaps it's a short-term interest, but then if it distorts competition and has a harmful effect in the medium term. So I would say it's really about emphasising the implications for the sort of medium to long run effects, but it is a very difficult exercise.
Can I just, add one thing to this? I think that the question raised by Sam is quite important in an international context, because I mean the argument could be made that the issue is not to convince government not to intervene, but I mean to the extent at least that intervention by government, for instance, in terms of supporting national champions, could be a rational and appropriate response to another government doing the same. If indeed, I mean, there is a foreign government that implements a policy such that it is supporting its own national champion, it's not entirely clear that the best response is to tie the hands of governments in other jurisdictions. I mean, of course, the first best would be an international framework in which there are some constraints on the extent to which governments can intervene to support national champions, but in the absence of such a binding framework, it's not entirely clear that tying the hands of the governments that could potentially respond is the best course of action.
Thank you. And indeed, yes, the international dimension is very important. We looked at trade agreements in one of the sessions of the Global Forum of Competition, and we had with us François-Charles Laprevotte, who's done a very nice review of many trade agreements, and indeed provisions on subsidies or state aid were not very detailed or prevalent. apart from agreements that involve directly the EU. And in other cases, it only concerned exports, so it was a varied picture, so to speak. There was also a second leg to the question, and it was about whether the OECD is working towards a legally binding treaty for governments to respect competitive neutrality principles. So the answer is no. The OECD recommendation was already approved at the highest level by ministers at ministerial level. We conduct outreach and we advocate for the implementation of these principles, not just by OECD countries, so not just by adherence to the recommendation, but more generally by other jurisdictions. And it is in this context that we hope to develop some guidelines to help, hopefully, to implement competitive neutrality. We also have a question by Sheila Scobie. There has been much said about the need to balance certain public policy benefits against costs in relation to distortion of competition and markets. Who is best placed to conduct that balancing? Politicians or independent technocratic agencies? Okay, I imagine a variety of points of view on this. Please go ahead, turn on your microphones.
I would say the best place would be an independent sort of competition agency to undertake that assessment. Because if you think about the state aid context, that balancing exercise inevitably involves a degree of subjectivity. So in that particular context, a supranational authority like the Commission is far best placed to do that than the individual member states. Having said that, with following Brexit and now in the UK, under state aid rules, there's now far more emphasis on the individual aid grantor doing that balancing exercise themselves to determine whether the aid is likely to be, for the positive effects, are likely to outweigh the negative effects. So it'll be interesting to see how that situation evolves in the UK context. But certainly I would say that sort of independent competition authority would be better placed just because of the inevitable degree of subjectivity involved.
If I may just add one thing to this, it seems that the answer to Sheila's question is that it can only be both. That is because some of the public policy benefits that are being considered in these balancing exercise, I mean, need to be informed by a public debate and need to be informed by decisions that are at some level inherently political. I mean, think about, one of the issues that you were raising, I think it was probably Federica at the beginning, about the current schemes in the EU towards support of the microchip design and production. I mean, there is a benefit from undertaking this depends on the value that you put on security of supply. And the value that you put on security of supply is something that cannot be assessed by technocrats alone. I mean, this is something that has a wider sort of social and political dimension, or to put it in economic terms, I mean, to put a price on the value of security of supply, as well as to put a price in the achievement of other public policy intervention, in information and a structured debate at the political level is probably inevitable and in the long term necessary in order to ensure the legitimacy of whatever decision is going to be taken by civil servants. So that, having a technocratic procedure only without a framework and without some direction from a political debate seems, to delegitimize the process in the long term, delegitimize the technocratic process.
Thank you all. It seems that we do not have any more questions. So I would close the session. I would close this panel, thanking the speakers, the audience, the questions, and just to wrap up, say that we've talked about state support, we've talked about challenges for competition authorities, but I think today's discussion has highlighted that competitive neutrality really has many policy dimensions, trade being one of the most obvious. So I would like to invite everyone to stay tuned and follow our next initiatives on competitive neutrality, and we hope to hear from you with examples or challenges from your jurisdictions. Thank you very much, everyone.